Yes, in this case, I do, Mr. Hearing Examiner. I don't recall what was this Mr. Haddock was our landman in this case?
Yes, sorry.
Mr. Haddock, where I think we left questioning off is off of the breakdown of working interest owners. Do you recall that exhibit? It should be on page 18 of 51 for case 25229.
Correct. So we're not gonna pull any of those parties. They represent about 4% total. So we can submit they've signed the J or going to sign the JOA, and so we can update it to show kind of a line item that shows the total percentage, and then a drop down of the remaining parties, and we'll mark them all as not pooled and we can submit that.
Okay, so Mr. Haddock, so essentially what you just referenced to me is you have the percent of interest that is entirely associated with BTA and potentially these other two persons. Is that correct?
Correct.
And on this table on page 18 of 51 that has the breakdown of working interest owners, does all those current percentages that's shown, does those add up to 100%?
They would be I'd have to look back at the source data.
Okay, let me ask you a different question. Are you presenting to me that once you include the percentage that's associated with these three entities, at that point, is the sum of this table going to equal 100%?
Yes, it will.
Okay. And if I were to ask you to include an additional statement in your in your firm statement, giving a very brief description of what's going on here, do you understand what I'd be asking for?
Just a quick explanation of why certain parties don't have
I guess
final determination.
Well, not to tell you what to affirm to or to certify, but just a written statement in regards to our conversation today. My current understanding is you do not know for sure what percentage may or may not be associated with Richardson and David versus BTA, but you know the overall percentage. Is that correct?
Correct.
And essentially what I'd be looking for is some sort of statement just saying essentially that you know the overall interest and currently you're just not sure which of those two parties. However you want to go about it is up to you.
Okay, we can do that.
I don't recall if I questioned the geologist or not in this case, but I do have a question for him or her. I don't remember who it was now. What?
You did, and I believe he's still on the line.
Yes, sir.
Oh, Mr. Hendrickson, is that correct? Did I question you in regards to? Well, let me just ask the questions again in case it didn't come through. That's the disadvantage, I guess, of jumping around from these cases. I don't recall if we addressed it here or not. But let me see if I can find the page. On this case, that being 25229, Mr. Hendrickson, I'm looking at your cross section in Exhibit D4, page 42 of 51.
Yes, sir. You'll have to forgive me. I'm looking at the PowerPoint version, but it's the same as what you should be seeing.
Okay, I'm with you. And I think it was another case that we talked about with this exact same scenario. I don't think it was this case, but I could be wrong. Where you reference on the right-hand side, you say this is the pooled interval. Is that representative of what the applicant's requesting to force pool in this case?
Yes, we are seeking to pool a third Bone Spring in this case.
Thank you, Mr. Hendrickson. Ms. Vance, on the CPAC, it represents that, and in the landman statement, it represents that Permian's requesting to force pool the entirety of the Bone Spring formation. We're going to
Yeah.
need to correct that if that's no longer the case.
That's correct. I can get those updated.
Okay, and you understand everything I'm asking for there?
Yes, similar to what we discussed with the oxysoro.
Yes, sounds exactly so. In addition to that, the only other thing I'm looking for is my in regards to my discussion with Mr. Haddock in regards to those three parties that have to be determined title, and then an updated breakdown of the interests.
Okay, and that is for both of the cases because because both of them have that TBD.
That is correct. For the other case in regards to the GEO exhibit, actually, I apologize, but let me confirm with Mr. Hendrickson. On your cross section, it looks like you reference the upper Wolfcamp as being your pooled interval. Is it your understanding that that is what Permian's requesting to force pool in case 25232?
Yeah, you alluded to this earlier, but what we've discussed previously was this is the more appropriate way to refer to this as the targeted interval rather than the pooled interval. We're seeking to pool the entire Wolfcamp formation. What's shown here is more or less what we're targeting for this project.
Okay, thank you, Mr. Hendrickson. Ms. Vance, I will also need an amended cross section in case 25232 with that pooled interval correctly identified as targeted interval.
Okay,
And I believe that's everything I have for these two cases.
Thank you, Mr. McClure. Ms. Vance, how long do you want the record to stay open?
416 sounds good.
At 4:16, close of business. And Mr. McClure, those exhibits were for both cases or just one case?
The landman, the working interest is for both cases. The
Okay.
cross section is
Okay.
for case, the Wolfcamp case 25232.
Okay, very good.
And
Ms. Bennett,
Mr.
did you have something to say?
No, I just appeared in these cases, so I was just paying attention.
Well, that was nice of you. All right. Well, it looks like we are done with our regular docket so far. And at 1 o'clock, we are going to begin a motion hearing. So we all have a 4-minute break.
Mr. Hearing Examiner, can I ask Ms. Vance a quick question? I do not know for sure which cases it applies to, and I was
Go right
hoping
ahead.
she knew. Ms. Vance, I do not know if it which of the U wells it applies to, but in one of the cases you made reference verbally that there may be existing hearing orders that is now being changed. I believe it's the first set that we talked about.
Yes, so you mean the extension cases or are you?
No, it was one of the ones that is one of these U-turn wells that we were talking about, like the Bone Spring 3 versus
Oh,
the
that
entirety
they're-
of the Bone Spring.
That there were existing orders? Yes, we actually dismissed those cases,
Oh.
so yeah.
Okay, so then there are no actual hearing orders that need to be terminated or dealt with in some manner then. to your
No.
understanding.
No.
Okay, thank you, Ms. Vance. I'm sorry, Mr. Hearing Examiner, that was all I had.
Sounds good. All right, we're going to take a 3-minute break and come back at 1 o'clock. Thank you. It is 1:03 in the afternoon. We are now calling 11 cases for a motion hearing. Those cases are 249-4142, 249-9495, 25115-1617, 25145, 4647, 48. Entries of appearance, please.
Darren
Good
Savage. Go ahead, Paul.
Go ahead, Mr. Savage.
Good afternoon. Darren Savage with Aberdeen Shill appearing on behalf of VF Petroleum Incorporated.
Thank you, sir.
Good afternoon, Mr. Herring, Examiner Paula Vance with the Santa Fe office of Holland and Hart on behalf of Reed and Stevens and Permian.
Thank you.
And Caitlin Luck here on behalf of Carolyn Bell. I'm sorry, I'm still having some connection problems. So when I turn on my camera, then it causes my connection to cut out. So I'm here though via audio.
Okay. All right. Let's review what we are doing today. We have conducted 2 full days of hearing in these cases, in these consolidated cases. First on January the 28th, then on February the 27th. After the hearing on February 27th, Mr. McClure, our technical examiner, had a list of supplemental exhibits from 2 of the 3 parties. From Ms. Vance, he asked for an amended CPAC pooling administrative checklist to include all depth severances. If space is limited, list the depth separately and cite landman's statement for reference. Ensure the depth severance for the entire bone spring is listed in each relevant case. Exhibit C3, a summary of interest. I'm not going to go over all the details there. Then a landman's statement corrections, remove typo or duplicate reference regarding vertical limit. Ensure accurate reference to bone spring 3 vertical limit. Correct bullet point lists of vertical limit to case specific. Add paragraph describing all depth severances, including misbeals. Number 4, supplement exhibit on depth severance at 9397 feet. Provide a document, if available, showing this depth severance in the southeast quarter of the southwest quarter. If no documents exist, provide a detailed description. If title documentation is available, submit a limited version to clarify ownership severance. Exhibit C9, summary of committed interests. I won't go through all of those. And then Exhibit D7, a geologist cross section. Again, focusing on vertical limits, etc. So as you can see, Mr. McClure is quite concerned about vertical limits, depth severance. Resubmission of book 143, page 191, submit as an exhibit packet, not just as part of a notice of ownership. 2, proposed allocation method. And 3, table identifying Ms. Beal's interest, providing a table or document showing Ms. Beal's interest percentages for the north half of sections 14 and 15, and the south half of the north half in sections 14 and 15. Ms. Luck, you submitted, and there I can see you now. You submitted an exhibit, a supplemental exhibit packet. Your exhibits, I think you listed them as 2 and 3. They don't say who they're from.
And I apologize, when I turn on my camera, I have connectivity issues. So the exhibits that I submitted were from Jordan Shaw, our landman who testified at the February 27th hearing.
So you're saying that Mr. Shaw prepared both exhibits 2 and 3?
That's correct.
Okay, well, there's nothing in the exhibits to say that. You can call him today and lay a foundation for your exhibits 2 and 3. and we'll decide what weight to give them after we hear from them or hear from him, and then see about the cross, if there's any cross-examination. But as it is now, they have no evidentiary weight whatsoever.
Okay, and Mr. Shaw testified to that information at the February 27th hearing. He went through his determination as to his review of the title to confirm that Ms. Bell owned an interest. He described the before payout and the after payout explanation. He also explained the reason for the allocation formula in the table that we put together to propose allocation in this unit for Ms. Bell. And so I do believe that a proper foundation was laid at the February 27th hearing for both of those exhibits, and they were simply submitted after hearing because we discussed those at hearing, and they weren't submitted with an affidavit or anything to that extent because Mr. Shaw, again, testified on the February 27th hearing about both of those exhibits in pretty great detail about both his reason for his determination about Ms. Bell's interest in both of those units, as well as the proposed allocation formula.
Okay, Ms. Luck, I'm not saying that his testimony is not evidence. It is. What I'm saying is your exhibit 2 and 3 are not going to be given any weight unless he adopts them under oath today.
Okay, I understand. I just want to be sure that we did discuss those at the February 27th hearing in addition, but he is here and available to testify.
Right, exactly. I'm just letting you know what you need to do today to get those exhibits admitted as evidence and not just as sort of a demonstrative piece of a document, okay?
Thank you.
You're welcome. All right, so Ms. Vance, the list I read earlier, is that comport with your understanding of what Mr. McClure wanted?
Correct, yes.
All right,
it
very
does.
good. Okay. So now that we've talked about that, I'd like to go into the motions that bring us here today. So let's review. On March 21st, we have a motion submitted by Carolyn Beal to strike your exhibit C12. And there was a request for a hearing. Also on March 21st, we had a motion by Permian to strike the intervention of Carolyn Beal in case number 25146, which deals with the south half of the north half of section 14. 3 days later, VF filed a concurring motion to strike exhibit C12. Then on March 26th, we have your response, Ms. Vance, to both VF and Carolyn Beal regarding your exhibit C12. Then on March 26th, we have Carolyn Beal's response to your motion, well, to Permian's motion to strike the intervention. Then on April 4, we have both VF and Carolyn Beal filed a motion to limit the hearing today. And then on April 9, we have your response, Ms. Vance, to the motions to limit the hearing. So those are the motions that are before us here. And the way I propose to deal with those motions is to first take evidence on exhibit C12, allowing the parties to cross-examine the witness supporting exhibit C12. And we'll go from there. So Ms. Vance, are you prepared?
I have Mr. Maka available to discuss the exhibit C12.
Okay. Okay. So then we don't have the author who drafted the opinion letter as a witness today.
That's correct. No.
Okay. Okay. It's your case. So you're going to present it in whatever way you want to. Do you want to make an opening statement about exhibit C12 before we begin?
I'll make a very short
Whatever you want, Ms. Vance. It's whatever you want.
And Mr.
Okay.
Hearing Examiner, if I may, I think it's improper for Mr. Maka to testify to the title opinion that was drafted by someone else. It looks like it was signed by David Hubble and Jeffrey Lear. And I don't believe that Mr. Maka is qualified to testify on behalf of those folks unless there's a proper foundation laid that he has some affiliation with them or he is an attorney who can testify for Lear and Lear. I don't believe that Mr. Maka can testify about this title opinion. I would object to that proceeding at this hearing today.
Okay, so what I will allow you to do, Ms. Luck, is to voir dire the witness after we get him sworn in. But at this point, we're just having an opening statement from Ms. Vance, and then we'll move into Mr. Maka, and you can make your objection by voir diring the witness, okay?
Okay.
Ms. Vance?
Yes. So one, I just want to be clear that this particular deed of distribution was admitted in the middle of the hearing that we held last month, and it was the first time that Permian had taken a look at this document, and so immediately Permian took that document and did an analysis of it to understand it, because it was being used as a basis for Ms. Beal to substantiate her interests that she has claimed, specifically in the south half of the north half. And so we looked at that and responded or came to a conclusion based on the analysis that was provided. And concurrent with that, the technical examiner asked for information to clarify the depth severances. And so that information was provided, which there's only 2 depth severances that exist in these cases. There's a depth severance in the north half of the north half case, and there is a depth severance in the south half of the south half. And those are listed in the supplemental exhibit C12 that was provided. The reason why the opinion letter was included was to show that there was no depth severance as originally was claimed by Ms. Beal. That was the basis of her intervening in the case, in which she was granted the ability to intervene. And it is completely circular. There's no depth severance, and she does not have an interest there. That was also that was also discussed by her own witness, who repeatedly stated on during the last hearing that there were gaps, clouds. There was no way to confirm that interest vested. You know, we were asked by the technical examiner to provide clarification on what Ms. Beal's interests were and where the depth severance were. And that's what we did. Now, I do want to put a point on, and I stated this in my response, is that Ms. Beal is was allowed to intervene based on an understanding that she had a vertical offset. She was an affected party as a vertical offset in the south half of the north half. Again, her witness repeatedly stated that there is cloud on title, there is a gap, it cannot be confirmed. She does not have an interest in the south half, the north half. Again, she was allowed to intervene based on a depth severance as an offsetting affected party. However, when we got to the hearing last month, that changed. She is now stating that she has an interest in the entirety of that third bone spring in all depths. So, you know, I put it to the examiner that now that she is claiming something different than what she was allowed to intervene on, that sort of changes the circumstances, and it has caused some confusion here. But that being said, Permian is not seeking to pool Ms. Beal. Because as her witness confirmed, she doesn't have an interest. And even if she wants to clear that up, this is not the venue to do that. We're simply, just to put a point on it, provided the document, the opinion letter. To be honest, I don't think we anticipated that it would turn into this big back and forth of motions. But I leave it to, it is simply to have confirmed exactly what their own witness stated on the record. We concur. There is no interest in the south half of the north half because it has not vested. There is a cloud, there is a gap in title. So in terms of the opinion letter itself, I leave it to the discretion of the hearing examiner. The hearing examiner has the discretion to allow certain documents into cases and hearings, and the division may place whatever weight it wishes to on the document. That's all I have.
Thank you, Ms. Vance. Okay, now the witness that you have for to support this document is Mr. Maka. Is that correct?
That's correct.
All right, Mr. Maka, would you unmute yourself, please?
Yes, sir.
Okay, very good. Now, Mr. Maka, I swore you in earlier today, so I remind you, you're still under oath. Okay?
Yes,
now, Ms. Vance, the reason that we're here today is because there was an objection to your document. If it hadn't been objected to, I would consider it a rebuttal exhibit. I know that Ms. Luck presented you with a document during the hearing on February 27, and in all fairness, I do understand that this is a rebuttal exhibit. It does speak to both ownership interest, which we don't deal with here, and it does speak to debt severances and that sort of thing, which we do deal with here. Before Mr. Maka testifies, I want to review one thing with the parties. I did some research into the Oil Conservation's Division's powers and duties under the Oil and Gas Act. And when it comes to pooling orders, I'm going to review this. Now, I know Mr. Savage must know this by heart, but for me, I learned, and I'm sure Mr. McClure knows this as well, but for me, I learned that pooling orders generally identify all known working interest owners and mineral interest owners. Therefore, it is important for us to know as a division who we are compulsory pooling and who we are not compulsory pooling. So right off the bat, that says to me that identifying interest owners, whether it's been adjudicated or not, or whether there's a dispute about ownership, it has to at least be mentioned in the order, recognized in some way. Typically, we use exhibits. We use exhibits from the applicant to show ownership breakdown by tract, who was offered participation, who accepted, who declined, and those people that are being force pooled and the corresponding risk penalty applied. Typically, legal sufficiency requires that proper notice was given to all parties with a known interest, that the record supports the need for force pooling, and that the order provides for sufficient detail to support enforceability and protect correlative rights. Also, force pooled interests define participating owners and non-consenting owners. So ultimately, this information is relevant, and that's important because as a hearing examiner, I am not permitted to accept irrelevant evidence, and parties who make objections based on relevancy, will carry the day. So with that said, I can see the relevance of C12. And if the only objection was to relevance, then I would overrule that and tell the parties that we are going to accept Exhibit C12 and give it the weight that we deem sufficient. However, there are objections, and the parties have the VF and Carolyn Beal have requested the ability to cross-examine the witness. And so we have Mr. Maka here. Now we have an objection to Mr. Maka. So Ms. Luck, you've already stated your objection earlier, and I said that you could voir dire this witness as to this exhibit. So please go ahead.
Thank you, Mr. Hearing Examiner. And I would also like to respond to a few of the comments that Ms. Vance made about Ms. Bell's interest. So Ms. Bell was provided late notice of this hearing by Permian's own words as a vertical offset. And this is not a proper determination for whether or not there's gaps in title or whether or not she has a perfected interest in this unit. It is our understanding that this exhibit is only being submitted for purposes of disputing Ms. Bell's title interest. It doesn't talk about the depth severances at all. And so just looking at Mr. Maka's affidavit that was submitted with the March 10th exhibit packet, it doesn't even reference C12 at all. So I'm not really sure how Mr. Maka could testify to anything in C12 because it's not included in his affidavit. He didn't sign the document, and it's my understanding he's not associated with the Lear and Lear law firm. And
Okay,
so
Miss Luck, I asked, you're repeating yourself at this point. I've already given you the opportunity to voir dire Mr. Maka. You're not doing that. So again, you have an opportunity to voir dire this witness and ask him questions about Exhibit C12, and I'll make a decision based on your voir dire. So go ahead.
Mr. Hearing Examiner, respectfully, I would also object to Mr. Maka. I'd object to the opinion letter being addressed here. And if I may explain, based on some of the comments that you had made about the rules and law regarding pooling, if I could have an opportunity to address some of that.
We'll get to you after Miss Luck either takes her opportunity to voir dire this witness or not.
Yes, sir. Thank you.
well, so I mean, turning to Exhibit C12, Mr. Maka, did you draft this letter that's included titled opinion letter regarding the operating rights of Carolyn Bill?
No, I did not.
Okay, it looks like this letter is addressed to you. Is that correct?
That is correct.
And do you know the folks who wrote the letter to you?
They work with us as title attorneys, but that's my extent of relationship.
Okay, and does your affidavit that was submitted, it looks like it was signed on March 10th. Does it include Exhibit C12?
No, I don't believe so.
Okay, so there was no one in Permian's office that was affiliated or associated with drafting this title opinion letter that's included as Exhibit C12.
That is correct. We contract out our title opinions.
Okay, so why did Permian request this title opinion?
So at the last hearing, when the additional exhibit was presented and accepted in the middle of the hearing that we had not seen before, we wanted to kind of get eyes on that. Me, myself personally, I don't review the thousands of documents that go into a title opinion. We have to kind of let our title attorneys review those as such. And we wanted to substantiate any claims. Like, we understand that if someone owns an interest and we're not attributing that, we want to make sure that that's accounted for. So we sent those documents that were submitted to our title attorneys, and we asked them for a brief synopsis of what they thought. And this letter was provided to us. And to Paula's point earlier, we did not realize this was going to turn into a kind of back and forth of motions. This letter was purely meant to be additional information for the division to facilitate any sort of decision here.
So this opinion letter doesn't describe or have anything to do with depth severances.
I believe it does talk about some depth severances, but I think the depth severance in the north half is not in dispute. I think that we acknowledge that Ms. Beal owns in the shallower depths, and that interest is not disputed. So we did not address that specifically or request to address that specifically in this letter.
Okay, thank you. And so, Mr. Hearing Examiner, I would continue to object to this witness testifying about this title opinion document that's being submitted only for the purpose of excluding Ms. Bell's interest in this unit. I think that Ms. Bell has now submitted supporting documentation that she actually owns an interest in this unit. There's correlative rights issues, and this witness cannot proceed with testifying about a letter that was addressed to him. That's not appropriate. It's not included in his affidavit. There's no one affiliated or associated with Permian who drafted this letter, who took part in drafting this letter, and the letter doesn't reference or relate to any type of debt severances. It's completely undisputed at this point in time that there is not a debt severance in the south half, north half of these proposed spacing units. And so if that's undisputed that there's not a debt severance, then there's no further need for any further testimony regarding this title opinion letter. It's completely improper for the division to make any kind of title decision related to Ms. Bell's interest. That's for the district courts.
Okay, Miss Luck, did you just say that there's no depth severances in the south half of the north half?
Right, I believe that's completely undisputed at this point in time. And the first page of Exhibit C12 shows that.
Okay, so I'm looking at your closing statement that you submitted well, you know when you submitted it. And on page 2 of your closing statement, and this was submitted sometime in mid-March at the conclusion of both hearings, you say, Ms. Beal owns approximately 1% in the spacing units proposed in the subject cases with a working interest in the northeast quarter of the northwest quarter and the south half of the northeast quarter, the northeast quarter of the northeast quarter, and the northwest quarter of the northeast quarter, the southeast quarter of northwest quarter of section 14, township 18, range 31 east and MPM, comma, in the upper third of the third Bone Spring to depths 9290 in some portions and 9293 in other portions underlying the subject lands. And then you go on to say, and was provided notice in cases, blah, 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 as vertical offset. So in this document, this closing argument that you submitted, you refer to a depth severance.
Right, and now it's my understanding after having reviewed this further that Ms. Bell's interest and the depth severance is only in the north half unit. And I believe that that's what Ms. Vance's statements were earlier too, that there's not a depth severance in the south half, north half unit. There's only depth severance in the north half unit.
I'm reading your words in your closing argument.
No, I understand that. And I believe that that is an error, that Miss Bell actually owns a non-depth severed interest in the south half, north half unit.
What are you relying on to change your position from your closing argument submitted weeks after the hearing in which your witnesses testified? You introduced the document that you're now saying changes your position. So what are you relying on at this point?
I'm sorry, I believe that it's undisputed at this point in time that there is not a depth severance in the south half, north half unit. And my representation in that motion, in the closing statement, appears to be incorrect and needs to be amended to clearly state that Miss Bell owns an interest in 25146 in the third Bone Spring formation. It's not
Sure.
a depth severance.
And I'm asking you again, what are you relying on?
I'm sorry, the interest ownership documents that we submitted with her notice of ownership interest support that. I made a misstatement about what those documents state because I misunderstood what those title documents reflected. That was a misstatement by counsel in the pleading that needs to be amended to reflect that Miss Bell owns a non-depth severed interest in the south half, north half unit.
Well,
And the document, is referenced. It's page 225, 980.
I don't know what you're talking about right now.
Apologies. I filed a document with Miss Bell's ownership interest that is book 225, page 980.
I
That
have all your
reflects,
documents. I have all your documents here. So that doesn't answer my question, but I do understand that you made a mistake. That's a pretty serious mistake to continue to assert that there's a depth severance when now you're saying there is no depth severance. But the opinion letter from Lear and Lear does specifically go into important things that the division needs to know. For example, that the chain of title, this is from the opinion letter. It talks about the lack of recorded title evidence. Now, Permian can only provide notice to those that provide recorded title evidence to the public. And in fact, this chain of title to Jean or Charles Reed for those interests is not supported by constructive notice in the public record. So the fact that Permian didn't see this potential ownership is explained by this letter, number one. Number two, this letter identifies specific shallower depths conveyances from Reed and Stephen. For example, the southwest quarter of the Northwest, book 112, page 1035, the depths are from 3,900 to 4,611 feet. In the Northwest, book 114, page 196, the depths from 3,900 to 4,552 feet. These fall short of the target third bone spring interval, which starts at the 93-97. This is relevant evidence for the division to consider. Now, your voir dire of Mr. Maka basically supports your objection that he didn't produce this document. However, Mr. Maka, so before I even go on, Mr. Savage, would you like an opportunity to voir dire this witness?
Yes, sir.
Please go ahead.
And I would like to make a few comments if I could about.
No, it's not time for comments, Mr. Savage. It's time for you to voir dire this witness.
Okay. Mr. Maka, as was stated, as you stated previously, it's correct that you did not draft this opinion letter.
That is correct.
And do you consider this opinion letter as being written testimony to the division?
I would not consider it to be testimony since our attorneys are not available. I think that's a little bit of a legal question.
Okay. If I remember correctly, you did not make it to the January 28th hearing. Is that correct?
That's correct. Yeah.
But isn't it true that you submitted a written statement for that?
Yes, that is correct.
Okay. And you identified it and defined it as written testimony. Is that correct?
That is correct.
So why is this opinion letter not written testimony?
I'm not sure. I'm sorry.
Okay,
I don't know the answer to that.
Okay. So the drafters, they wrote this statement. They make these written assertions and statements to the division like you did in yours, but they had not shown up like you did not. And the Permian is submitting this as a written statement. Is that correct?
That is correct.
Okay. Mr. Maki, how long have you been a landman?
About 9 years.
Okay, 9 years. And your educational background is specifically in land management, I assume?
That is correct.
Okay. Have you worked as a field landman or have you always been in-house?
I have been a field landman, yes.
You have been a field landman, okay. Can you describe when does a field landman, are they often asked to draft ownership reports?
Yes, sir.
Can you describe the process if I asked you to do an ownership report on the south half northwest, the south half, north half of section 14? Can you discuss the process?
Yeah. So with these being federal leases, we would run from the inception of that lease forward, since upon termination of a federal lease, it kind of wipes the record clean. So I would start from the inception of a federal lease. I would cross everything through the county abstract per legal description. Then I would cross everything through the grantor and grantee index for every party that was in that chain of title. I would also order federal and state abstracts for any chain of title that has been filed with the BLM. And then I would compile that information for detailed review and put that chain of title together to make my opinion.
Okay. And in this process, you would read and review the lease, the base lease,
That is correct.
and you would read and review every assignment in the chain of title. Is that correct?
That is correct.
And you would analyze and interpret the language, such as the language of conveyance in those assignments.
That is correct.
So as a landman, you in 9 years, you have quite a bit of experience with reading, reviewing, and interpreting, such as language of conveyance.
Relatively, yes.
And you understand language that conveys working interest.
Yes, sir.
And as a landman, you would review title documents to arrive at basically the same conclusion of ownership that the opinion letter has provided, but without, so let's say, legal requirements. Would you agree with that?
Sorry, can you repeat the question?
Okay, so let's say that you were in the field and you were trying to determine the property rights of Miss Beal, for example, okay? So you would look at the base leases, you would look at subsequent assignments, you would look at the language, and then you would draft an ownership report. And in this ownership report, you would reach a conclusion that Beal does not own interest, for example, or you could reach a conclusion that she does own interest. Is that correct?
Yes.
Okay. Okay. I'm going to shift gears just a little bit, but I want to go back to the foundation that was laid, that you are experienced at reading assignments and drafting ownership reports. But you were present at the February 27th, 2025, at that hearing, at the conclusion of the hearing of the subject case, is correct?
Yes, that was.
And I believe you understood, you heard what Mr. McClure asked, and you understood what he was requesting.
Yes, for the most part. I don't remember exactly what he said as of today from them, but yeah.
I'm going to ask this. So I go, do you recall that Mr. McClure wanted a title document that described the depth severance, if it were available, describe the depth severance at 93, 97 feet, so the division could better understand the depth severance in relation to the vertical extent of Permian spacing units that the division was being asked to to pool? Does that sound like a fair statement of Mr. McClure's request?
Yes. Our understanding was that VF provided those documents. This opinion letter kind of just provides that the chain of title leading into those documents was not perfected.
Okay. And let me ask this specific question. So the opinion letter, does it describe in any way a depth severance around 9,400 feet?
No, it does not.
Okay, it does not. Okay. So on February 27th, you testified in your written statement that an ownership depth severances exists in the Bone Spring Formation with the proposed well spacing, and therefore Permian seeks to pool only a portion of the Bone Spring Formation for each of its cases. Is that correct?
I believe so.
Mr. Hearing Examiner, I'm going to object to this line of questioning. The voir dire should be substantiating whether or not this witness is credible to talk about the document, and we're getting into an entire new contested hearing. So the relevance of this, I'm objecting on a basis of relevance.
Okay,
And Mr.
Mr.
Hearing
Savage,
Examiner?
Mr. Savage, I asked you to voir dire this witness about this exhibit. Do you have any other questions about this exhibit before I make a judgment on whether or not I'm going to let this exhibit in?
So what we established is that it goes directly to his ability to address the ownership issues in the exhibit. It goes to, so there's a number of issues that are integral to this inquiry. So one is that Ms. Beal submitted title documents, not just to show that she was a party to be pooled, but to show that she had standing. And that was what the intervention was ruled on, that she met the threshold ownership for standing. Now,
Mr. Savage, that's not correct, Mr. Savage. I never adjudicated her ownership interest. I allowed her to intervene because the rule allows me the discretion for someone to protect their correlative rights, even if there is a slight possibility that her correlative rights may be at issue here. And that's why I allowed her. It had nothing to do with her specific ownership interests.
well, if she doesn't have ownership rights, she doesn't have correlative rights. If she has correlative rights, it's based on ownership rights, Mr. Hearing Examiner.
My understanding, Mr. Savage, of the language of the testimony on the first day of the hearing, January 28th, was that producing from one part of the bone spring may drain her ownership interests in another part of the bone spring. And she had been verified to have ownership in the southeast of the northwest. I don't know if I'm saying that correctly, but I'm doing this from memory. So there was no question that she had an ownership interest off a vertical well that she had an interest in. On that basis alone, I allowed her to intervene.
So, Mr.
I
Hearing,
also denied the motion to not allow her to intervene. Okay. It was only until the second day of the hearing in February when her interest somehow expanded into the south half of the north half. Okay.
And
these
Mr.
are
Examiner,
important.
sorry, I'd like to clarify that we did submit those supporting documentations, the book 225, page 980, that supports her interest in the south half, north half unit, and that was provided in advance of the hearing. There was further questions about whether or not a gap in title exists, and that's why the additional documentation came up at the hearing. And I want to clarify that this is relevant testimony that Mr. Savage was trying to get from Mr. Maka, because the issue about the depth severance started with Mr. Maka's affidavit that was filed before the January 28th hearing. If you pull up his affidavit that was filed on January 27th, it materially changes to the affidavit that was filed on March 10th with respect to the debt severance. Paragraph 7 says
exactly, Ms. Luck, and that is what I've been trying to get at, that your closing statements relied on Mr. Maka's testimony that there is a depth severance in the south half of the north half of section 14. That testimony is clear, it's unambiguous, and it's also unambiguous and clear that he changed that testimony when he submitted a new affidavit with revised testimony, new testimony on March 10th.
Mr. Savage, who are you talking about, Mr. Maka?
Mr. Maka.
Okay, so we're not, so that's a different issue. Right now, we have to deal with one issue at a time. If we're lawyers, we have to deal with one issue at a time. Okay, I also take exception to Ms. Luck and Mr. Savage, both sort of going back and forth, taking turns. You know, you're just here to voir dire. Okay, the voir dire period is over. Now I'm going to make a decision.
Okay,
Mr. Maka.
If I may comment, We are responding because you have conflated depth severance with ownership in that opinion letter. So in order to address these issues, we have to address them in this manner.
Mr. Savage, that exhibit, we're here right now to decide whether to strike the exhibit or not. That's all we're here for at the moment. And we don't have Mr. Hubble, who drafted this letter, in front of us.
That's correct.
So
And it should
now,
be struck on that basis alone. It
well,
should be
no,
struck.
actually, there's no rule here of evidence that says that I need to strike that letter.
Well, we
If
could
it's
use,
relevant and if it's
Mr.
relevant
Herring's-
and reliable, I can let it in.
we could
Now, we're
use,
trying to determine the reliability of this evidence so that
Okay.
I can either make a ruling. That's
Okay.
why you're questioning Mr. Maka. I know that you and Ms. Luck have many other things on a list of things that you want to do, but right now I'm dealing with this exhibit C12. Okay? Now, both you and Ms. Luck have had plenty of opportunity to voir dire this witness, and now I'm going to make a determination.
Mr. Herring's,
So,
if I may
so
add,
enough, Mr. Savage, enough.
for your benefit, if I may add
Enough.
for your
I don't
benefit.
need any more benefit.
Okay,
I don't
thank
need
you.
your benefit. Thank you. I've given you an opportunity to cross-examine, to voir dire this witness, as I did Miss Luck.
Well,
So,
I
Mr.
object
Maka,
because I don't
Mr.
feel like
Maka,
I've
I
had
have
a
some
fair
questions for you.
opportunity
So
to
maybe
do my
we need to
examination.
mute you, Mr. Savage. Maybe we need to actually mute you because this is becoming unprofessional at this
Yes,
point.
sir.
Right. Thanks for agreeing. Mr. Maka, I have some questions for you.
Yes, sir.
How long have you been working with Mr. Hubble at Lear and Lear?
David's been working on our opinions for probably about, I would say 18 months roughly, but I'm not sure exactly the date.
Okay. And did Mr. Hubble produce this letter based on your request?
That is correct.
Okay. And has he produced other opinion letters for you in other cases?
No, we have never had to do a letter opinion for a compulsory polling case like this before.
Okay. All right. When you got this letter, how do you use this letter?
So we viewed this letter as taking the additional exhibits supplied from the last hearing and just giving a blank, unbiased third party, give me your opinion and synopsis of the Carolyn bill interest in section 34 that is as disputed. And the northeast of the northwest depth severance was just not the as disputed part. And maybe that was a communication error on my behalf to our attorneys that they should have discussed that a little bit more in depth in this letter, but we were just trying to confirm any discrepancies or disagreements between the parties as to the interest to clarify for the OCD.
Okay. All right. So here's what I'm going to do. So Ms. Vance, the troubling part for me is that on March 27 at the status conference, when Mr. Hubble wasn't available, I said to you that these parties, Mr. Savage and Ms. Luck, are going to want to cross-examine Mr. Hubble. They made it abundantly clear that they wanted to cross-examine Mr. Hubble. In fairness, I scheduled another hearing for today, but I also left it open to you to pick another day if Mr. Hubble wasn't available. Do you know why Mr. Hubble is not available today?
Yes, and Mr. Maka might be able to backfill on this, but it's my understanding, to Mr. Maka's point, that the authors, they are third party. They did not, they prepared this just as an unbiased analysis of the document that was entered during the hearing. And so their position is they're not trying to argue for a particular side, and so take a neutral position. So it's simply just to provide an analysis of what was entered. I'd like to provide just a touch more color, or if I do have an opportunity to ask or rehabilitate or ask Mr. Maka some questions regarding his oversight of this document.
Okay, go ahead.
So Mr. Maka, actually the hearing examiner asked a couple of the questions that I was going to ask you. did you provide the documents that did you provide the documents to the authors, Mr. Hubble and Mr. Taylor, that are discussed in the opinion letter?
That is correct.
And where did you get those documents from?
They were supplied by Mr. Savage or Miss Luck.
Okay, and do you, is it a common practice for you to oversee the documents that you provide to your title attorneys
Yes,
when you
ma'am.
submit them?
Yes, ma'am.
And then, yeah, that's all I have. That's enough.
So Ms. Vance, the way I look at this is, we have Mr. Maka here, and he can testify to the information that he received from Mr. Hubble, and he's available for cross-examination. And if he can supply some sort of reliability to the information, that's one thing. The problem I'm having with this opinion letter is it's an opinion from someone who is not available for cross-examination. I don't know what his expertise is. I don't know how he derived this information. Some of the information is irrelevant. Some of it is relevant. But at this point, the biggest problem I'm having is that I made it clear to you that if you wanted this exhibit to survive this motion, that he better be available for cross-examination. He decided not to be, that's fine. But for that reason alone, I'm going to strike this exhibit from the packet, and Mr. McClure won't give it any consideration in his order. However, if Mr. Maka wants to testify to any of that information, because hearsay is admissible in an administrative hearing, and we will give it the weight that we deem it that it deserves, then I'll give you an opportunity to have Mr. Maka testify. Is Ms. Luck, is Mr. Shaw available?
Yes, he is.
All right, good. Can you get him on the screen, please? Excellent. Mr. Shaw, I think I swore you in earlier, did I not?
Yes,
Oh,
sir.
I did. So I remind you that you are under oath as well. I want to deal with these two exhibits before we go back to Mr. Maka, because they're in Ms. Luck's exhibit packet. Did you prepare exhibits 2 and 3? I think they're actually labeled.
Is exhibit B and C?
That's what I was going to change. Yes,
Yes, sir.
They're B and C, yes.
Yes, sir.
You prepared them yourself?
Yes, sir.
Okay, very good. Ms. Luck, do you want to ask any other questions to lay a foundation for these two exhibits before I see if there's an objection to them?
And Mr. Shaw, you've been qualified as an expert landman before the OCD before, is that correct?
Yes, ma'am.
And you have extensive experience in reviewing title and making the title determinations in the Permian, is that correct?
Yes, ma'am.
Okay, and did you prepare these two exhibits for purposes of these hearings?
Yes, ma'am.
Okay, and are you familiar with Miss Bell and her title interest in these two cases?
Yes, ma'am.
Okay, and I think that's all the questions that I have for this witness, and I would move the admission of exhibits B and C as prepared for purposes of this hearing of establishing both Miss Bell's ownership interest in case 25145, 25146, and a proposed allocation.
Ms. Vance?
Sorry, and again, I just want to confirm, because we were saying exhibit 2 and 3, that we are talking about exhibit B, which is page 60 of 61, and exhibit C of
Yes.
61. Okay, I just want to be clear.
Yes.
Yes, I mean, I'm going to object. One, the division does not the division does not approve allocation formulas. That's typically done between parties. Pooling is done on a surface acreage basis, and so I don't believe it's appropriate to have the allocation formula included. Even if it is, what I would say is based on the testimony of their own witness, Mr. Shaw.
I'm going to object to this line of questioning, and the reason is because it's outside the scope of the purpose of this evidentiary hearing is talking about allocation formulas, and that was not the subject matter of this hearing.
Well, Mr. Savage, I'm giving Ms. Luck an opportunity to lay a foundation to bring in her exhibit B and C, which were basically unauthored in her exhibit packet. And one of them is the allocation formula. I asked Ms. Vance if there was an objection to B or C. And so this is not outside the scope of this hearing.
Well, and again,
Go ahead, Ms.
Mr.
Vance.
Hearing Examiner, we reviewed these exhibits at the hearing in February. The foundation was laid back then. Ms. Vance was given the opportunity to object back then. Mr. Shaw went through each of these and all of this information at the February hearing in this matter. And so again, I agree with Mr.
These
Savage that
documents
going
were
into the
not available
allocations.
for review. They were filed after the fact. And to point out, this is being a little hypocritical that the parties are upset about there not being a self-affirmed statement from Mr. Hubble or Mr. Taylor, and these two documents have just been provided without having a statement attached to them attesting to who created them, how they were created, etc. So that was going to be my last point in terms of discussing an objection, but I'll go ahead and state that now. The last thing I would say is in regards to even if the division allows these to come in, at this point it is clear in case number 25146, Ms. Beal does not have a vested interest. Those are the words of her own witness, Mr. Shaw, who repeatedly said on the record that the interest, that there is a cloud, there is a gap, it is not vested. And until they can show that, which does not happen at the administrative level here at the OCD, then there's no reason to include that information. Now, if they can substantiate that by going to a district court and clearing up title, fine. We can come back, we can pull Miss Beal, or we can pull Miss Beal right now out of an abundance of caution. But at this point, it's their own witness's testimony.
Okay,
And
she does
okay,
not
thank you.
own an
I got
interest
it.
there.
I got it. We don't need to go on about this forever. Let me ask you a question, Mr. Shaw, before I forget. Exhibit B, proposed allocation formula. Is this document true and correct to the best of your knowledge?
Yes, sir.
Do you have any changes you want to make to it at this point?
No, sir.
Okay. Exhibit C, same questions. Is it true and accurate to the best of your ability?
Yes, sir.
Okay. And are there any changes you want to make to it?
No, sir.
All right. All right. I'm admitting exhibits B and C. There's enough foundation to let them in at this point. I understand your objections, Ms. Vance, but I'm overruling them for now. Those documents are coming in. I have excluded C12. Mr. McClure understands that, although I'm not excluding the part of C12 that has the map on it. So that first page is admissible. It's the opinion letter that is excluded. Now, we have Mr. Maka here. Okay, so Ms. Vance, do you want to ask Mr. Maka any questions? Because I'm going to turn this over to Mr. McClure, because he has a list of questions for all the parties that he needs to clear up at this point. So do you want to just wait and let him do that first?
Yes, I think that's fine, because then if there's anything I need to clean up on the back end, I'll do that.
Okay, Mr. McClure, you have Mr. Shaw. Mr. Shaw, turn on your camera. You have Mr. Shaw and you have Mr. McClure. Who do you want to ask questions?
You mean you were asking about Mr. Marker or Mr. Shaw?
That is what I mean.
Okay, I apologize.
No, it's fine.
Most of my questions in regards to Ms. Bell's exhibits is cleared up now that we discussed Ms. Luck's closing arguments. Just for clarity, I could ask him a couple questions about Exhibit C, though. Mr. Shaw, I'm looking specifically at the Exhibit C found on page 61 of 61 of Ms. Bell's exhibits.
Yes, sir.
Okay, to confirm that I have an accurate understanding here, is your top table only referencing depth severances within the northeast quarter, the northwest quarter?
Yes, sir.
And is it correct that you're stating that between the depths of 9290 and 9293, there's a different percentage of ownership than above 9290?
Yes, sir. It looks like a scrivener's error, potentially, but that as per record, as to title, that it would be correct. Yes.
Okay. Now, your second table here, is it correct that this has no depth severances and this is referring to ownership from the surface to the center of the earth?
Yes, sir. Well, I believe it's from shallower depth. I believe it's from like 3,500 feet down to the center of the earth, approximately. But outside of the subject bone spring depths, yes.
Okay, so then technically where you say all depth is not actually correct. It's actually from 3,500 feet down then, is that correct?
I believe so, that's correct.
Okay, that's all the questions I have for Mr. Shaw. Mr. Maka.
Yes, sir.
Permium is asserting that Ms. Bell does not own an interest in the south half of the north half and additionally in the north half of the northeast quarter. Is that correct?
Yes, that is correct. We're just showing her in the northeast to the northwest quarter.
And in those tracts, who does Permium believe owns the working interest?
So that would be represented on our exhibit. Let me scroll up.
If you could please guide me, I guess, to where it is provided.
Yeah, it would be just the master tract capitulation tab of our exhibits. So that would mostly be Reed and Steven and Occidental. We own most of that stuff 50-50 together.
Now, Mr. Maka, if I can interrupt you, I guess, Mr. Maka, what you just referenced was for the entirety of the unit. Is that correct?
I'm referencing for the individual 40-acre tracts being in the south half and the north half of section 14.
Okay.
So
can you please guide, so that I'm on the same page with you, can you please guide me to where you're referencing that in your exhibit packet if you believe it's included there?
Yeah, I'm looking at the revised exhibit packet from March 10th. It's page 93 of 227. It's just our master tract capitulation.
Mr. Mock, I am on that same page. If you give me a few seconds to take a look at it. Actually, Mr. Marker, can you guide me to, specifically, I'm interested in, I guess, the northeast quarter of section 14 and the southeast quarter, the northwest quarter of section 14. Is that provided anywhere here?
Yes, sir. So in that very first column where you see section 14, east half, and then the south half of the northwest and the north half of the southwest, those legal descriptions will encompass the tracts that you're referencing, and that is Occidental, Permian LP, and then Reed and Stevens 50% each.
Okay, Mr. Mark, I guess I understand that, but where is the actual northeast quarter and the southeast quarter of the northwest broke out. I guess let me pause that question for a bit. Are you in agreement that the northeast quarter and the southeast quarter of the northwest quarter is a tract that is independent from your legal description here that includes the entirety of the east half of section 14?
I don't believe so. So the way that we've described these tracts on the capitulation is every tract that has analogous ownership for the most part, and or is a part of the same oil and gas lease. If that makes any sense.
It does, Mr. Marca, but to confirm as to which one of those we're talking about, are you in agreement that the south half of the southeast quarter is not a part of the lease that is at hand in this Lear and Lear statement?
Yes, that is correct.
So then are you asserting that what you have listed here for the first column, to be clear what we're talking about, are you asserting that, or is it your understanding that Reed and Stevens / Permian and Occidental each have 50% of the working interest, specifically in the northeast quarter and the southeast quarter of the northwest quarter, excuse me?
Yes, sir.
Okay. Mr. Hearing Examiner, in regards to this current topic, and I think everything for my understanding of a motion so far, at least, I think that concludes my questions.
Okay. Does that mean that you have other questions outside the motion hearing for these witnesses?
I don't think they're necessary unless the current hearing expands out some. I think we're fine as is. The division is, I believe.
Okay. Is there any cross-examination based on the questions that were asked?
No.
Okay.
You're muted, Mr. Savage.
Mr. Hearing Examiner, if I can, I do have one question.
Based on the questions that Mr. McClure asked?
That is correct.
For which witness?
That would be Mr. Maka.
Mr. Maka, go ahead.
Okay. So Mr. Maka, as Mr. McClure stated, you are claiming interest, and you and Occidental, or Reed and Stevens and Occidental are claiming interest in that southeast northwest to be pooled. Do you agree that if you are mistaken in that, and Ms. Beal does own working interest in that tract, that you will, Permian is the operator that runs the risk of Ms. Beal coming back in as a working interest owner?
Yes, sir. It would be, if that has been proven, we would either seek a JOA or a compulsory pooling.
Okay. Thank you, Mr. Maka. That's all the questions I have.
Okay. Miss Vance, you had said earlier that since there is some evidence that Miss Beal may own the entire third bone in the south half of the north half, that you would add her to your list of compulsory pooling.
Yes, I believe that if, just as Mr. Maka answered, if
Right.
Miss Beal showed that she had a vested interest, Permian would either offer her a JOA and try and work with her to get voluntary agreement, or we would come back and we would pool her interest.
Now, you had also said, as I remembered, or we could just add her to the pooled interest list.
As a precaution, if
Right.
that's where we are, I think that that's the route we would want to take, because we do not want to delay these proceedings any longer than necessary.
Okay. All right. So, Mr. Shaw, I have a question for you. Will you turn on your camera?
Yes, sir.
Okay. On February 27, during your testimony, and I'm looking at verbatim transcript, page 215, Mr. McClure was trying to flesh out this very issue. And he said to you the following. Now, was my understanding correct that earlier, or let me rephrase my question, does Ms. Beal own an interest outside of the depth severance, that being above 9290 or 9293? And you said possibly, but her title is vested when we can say 100% from depths 3900 to 9290. There's a cloud as it pertains to the other tracks and the other depths. Then Mr. McClure said, okay, now you said it's possible, but do you have any reason to believe that she does? And you said, yes, the existence of this document assigning an interest to her. Okay. You remember that testimony?
Yes, sir.
Okay. I don't know if you've done any further research or if you've thought about it any further, or if you've looked at the instrument at all since then, but do you have any reason to change your testimony now?
No, sir.
Okay. Okay. Mr. McClure, do you see any drawback to Ms. Vance or to Permian adding Ms. Beal to the pooled parties in case she does have an interest, and letting them work that out in the future after the order is issued?
The only topic that I would raise to your consideration, and it may be a moot point because she's already aware of this application and has taken part, is potentially she was provided notice as a offset vertical owner rather than as.
In what area are you talking about?
I believe it was in the case for the north half of the north half was where she was provided notice for as being a vertical offset owner rather than notice as a potential working interest owner. Having said that, she's clearly aware of all these applications. She's clearly got her attorney present.
Right.
So does that notice, is that even a notice concern? And I mean, obviously that's at your go ahead.
I don't know. Miss Luck, I think you're with us, aren't you?
Yes, Mr. Hearing Examiner, I'm here.
All right. Are you, I don't know that Mr. McClure's concern is valid or not. However, if Permian adds Miss Beal, your client, to the list of pooled persons in the south half of the north half, do you have an issue with that?
No, that would be preferable here.
I know it would be. I'm asking you on the record if you have an issue.
No, I don't have an issue with that. I would request that on behalf of my client, Miss Bell, that her interest be pooled appropriately in that case in 25146. Yes, Mr. Hearing
Now, it
Examiner.
may turn out that she has no interest, but that's not up to us. We don't deal with that, as you know. So what I'm trying to work out is some sort of a compromise to allow Permian's applications to be considered along with VF's applications, but without impairing your client's correlative rights.
Right. And the issue here with this, I think where my confusion came in, with Miss Bell's confusion came in, is in some applications, she was provided notice as a vertical offset. Permian's original landman affidavit states for cases involving the third bone spring, they were pulling only a portion of the bone spring. And so we just, Miss Bell's ownership in 25146, I think, is established in that case, but we don't want to waive any issues with respect to notice that may be pending before the commission, if that makes sense. I mean, I'm not exactly sure where the division is going to come down on this pooling application, but Miss Bell still filed her de novo application with the commission relating to not getting notice in this case. And so, I do want to continue to preserve her rights to appeal to the commission related to notice and whether or not notice was proper in that case.
That's your prerogative. So, Ms. Vance, how do you want to proceed with the application? Do you want to include Ms. Beal in the south half of the north half, or do you not want to?
Two things. One, I want to confer with my client to make sure that that's the route that we want to take. So even if we take a very brief recess, I just want to have that quick conversation. Two, I just want to, in reference to the pending or what were the pending commission cases, those were denied.
They
So, okay.
They were.
Thank you.
They were. Okay, do you want to take 5 minutes and confer with your client?
Yes, please.
Thank you. We're off the record.
Thank you.
Okay, it is 2:22 p.m. We are back on the record, Ms. Vance.
Yes, we are fine with pulling Ms. Beal with the caveat that our understanding, and we'd just like it confirmed on the record, that she is not going to later object to being pooled in this case, that we can go ahead and move forward with her as a pooled party.
Ms. Luck?
Oh, yes, I agree to that proposal. Thank you.
So no objection, Ms. Luck?
No objection. Thank you.
All right, Mr. McClure, is there anything else that we need to do today before I rule on these motions?
Yes, Mr. Hearing Examiner. I just want confirmation from Ms. Vance that we are referring to both the north half Bone Spring 3 case and the south half Bone Spring 3 case. Those being 25145 and 25146.
So, Mr. McClure, Miss Beal's interest was previously pooled in the 1 mile north half case. And as she already understands, she has an interest that is above the depth severance. So we would not be pooling her in that case. We would only be pooling her in case 25146. But before I stop, I did want to just get clarification and maybe I misunderstood because I thought I was going to be able to ask direct questions to Mr. Maka about the opinion letter, but it sounds like I was, Mr. McClure asked some questions. I don't want to revisit it, but I just, maybe I got confused. I thought I was going to be able to ask some direct questions to Mr. Maka about that. If
Did
not,
you have any, Ms. Vance, what subject matter did you want to ask Mr. Maka questions about?
He has familiarity with the letter, and I just wanted, there were a couple of key things based on his familiarity and understanding of the letter that I wanted to get on the record, if possible.
Okay,
And again, we
if
would
it-
object to that because I thought it
Okay,
was
hold
already
on, Ms.
excluded
Luck.
at this point in
Hold on,
time.
Ms. Luck. Ms. Luck, I didn't ask for your opinion for a moment. Hold on. Ms. Vance, if it has to do with depth severances, then I'll allow the questions. But if it has to do with ownership interests, we're not adjudicating ownership interests here.
Understood. That's fine then. We'll leave it as is. I think everything is fine.
Okay. Okay. So, Mr. McClure, I asked you a question and I'm not sure where we went with that.
I never actually finished. Ms.
Go ahead.
Vance stated that that Permium does not wish to
Right.
also pull Miss Bell in case 25145. I'm wondering if there was a miscommunication with her client or misunderstanding somewhere, because currently my understanding is that Mr. Shaw's testimony is that Miss Bell asserts she has ownership in the north half of the northeast quarter within the unit itself. Are you aware of that, Ms. Vance?
No, the positions have changed so much, it's hard to keep up with, but my understanding, again, is that her interest is above the depth severance, and where we would be pooling her is just in case 25146. That's what I discussed with my client, and that's where, I understand Ms. Luck, she agreed to that.
Let's bring Mr. Shaw back for a moment. Mr. Shaw?
Yes, sir.
Mr. Shaw, when you testified earlier to Miss Beal's possible holdings below the depth severance, everyone knows here that there's a depth severance in the northeast quarter of the northwest section. Is that correct?
Northeast quarter of the northwest quarter. Yes, sir. At
Perfect.
9,290. Yeah.
Perfect. Now, are you saying that outside that 140-acre piece in the north half of section 14, that Ms. Beal has interests that go below 9293, let's say?
Are you talking about in the northeast quarter of the northwest quarter?
No, I'm not. I'm not talking
Okay.
about that. I'm talking about outside. Ms. Vance is saying that she was under the impression that the only place that you testified that Ms. Beal potentially has an interest below 9290 is in the south half of the north half. Are you saying that she also has that in the north half of the north half?
Yes, sir. In the northeast quarter, south half of the northeast quarter, northwest quarter of the northeast quarter, and southeast quarter of the northwest quarter. So including Miss Bell in both of the north half cases for the third bone would pooling her interest would be sufficient.
So Ms. Vance, do you need to ask Mr. Shaw any clarifying questions before you discuss this with your client?
No, I'm prepared to just state on the record that we'll propose the same exact pooling her as long as she's not going to object.
Okay, Ms. Luck?
No objection to that.
Okay, so can I get an affirmative statement on whether you want to be included in that north half of the north half in case 45?
Yes, Mr. Hearing Examiner, Miss Bell would agree to being pooled into case 25145, if that is what Permium is proposing in this case, pursuant to Mr. Shaw's testimony. Thank you.
And Ms. Vance, so you're proposing to include Ms. Beal as a pooled interest in both case 45 and 46?
Ms. Luck, you're on mute.
No, Ms. Vance, I was asking you.
Oh, I thought you, I apologize. Can you restate the question?
Sure. So as it stands now, a little while ago, you came on the camera and you offered Miss Beal's counsel the opportunity to pool her client's interests in case number 46. That's the south half of the north half. Then Mr. McClure correctly brought out to your attention that in fact, Mr. Shaw's testimony goes toward a possible ownership interest below the depth severance in the north half of the north half, which is your case 45. So I then asked Ms. Luck if she prefers that for her client. She says yes, there's no objection, and that she affirmatively wants to be pooled in case 45 as an interest owner. Are you, if in fact she is an interest owner, so are you prepared to add her to that list as well?
Yes.
Okay. Okay, Mr. McClure, where are we now?
Just about over the hump, Mr. Hearing Examiner.
Right.
Ms. Vance, to confirm, your intent is to essentially submit another amended exhibit packet, which now has an amended forced pooled person list that includes Ms. Bell. Is that correct?
That's correct. And I held off on doing additional revised hearing packets till we came to the motions hearing today.
Yeah.
In case there were other things, I will go ahead and we will clean up Mr. Maka's statement to address all of the exhibits that he oversaw the completion of. And if there is anything else that the division requests, we will go ahead and take care of that.
Of course, Ms. Vance, I've granted the motion to exclude the opinion letter from Lear and Lear. So please remove that from your exhibits.
Not a problem.
Mm-hmm.
And Ms. Vance, the only other thing I would request is that we have a very brief statement that is describing the reason we're adding Ms. Bell in at this point. And whether you wish to, I'm assuming the best place would be in the landman statement.
I will do that. We will make a statement to clarify that we are pulling Miss Bell out of an abundance of caution.
Well, please, rather than abundant, well, you can include that language if you want, but please state something that describes that there's some sort of title dispute, however you want to go about doing it. And as Miss Bell asserts she has this interest, Permium doesn't think so.
Okay.
Is that agreeable with your thoughts, or do you have feedback on that?
No, that is fine. And I also understand based off of what you were saying that we would need to update the pooling exhibit as well.
Yes, well, the list of pooled persons. I believe that was your intent, but yes, the division would like to see that if you now wish to add Ms. Bell to it.
Yes, we can do that.
When would you like to submit that?
Let's go with the magic date of next
Okay.
Wednesday.
All right, April 16. Miss Vance, would you please forward that revised, please call it like the second or third, I don't know what number it is, but please title it something to make it distinguishable from the others. And please pass it to Mr. Savage and Miss Luck so that they can make objections if they see something that they didn't count on, that they can make an objection before we receive it.
Yes.
All right, sounds good.
So
Mr. Savage,
circulate-
is there any? Oh, go
Right.
ahead. I'm sorry.
Circulate before I file?
Please. Yes,
Okay.
please. Yes. That way, by the time you file it, we'll know that there's no problem and we can close the case, and then we can work on evaluating Mr. Savage's case and your case and work on an order.
Okay, thank you.
Okay.
Not a
Mr.
problem.
Savage, anything further?
So, Mr. Hearing Examiner, I would just say all this talk of pooling, of Permian pooling, Ms. Beal, I would just like to point out and remind the division that VF has competing applications, and our competing applications completely avoid all the
Right.
depth severance mess and
Right.
protect relative rights without dealing with depth severances that we feel like violate relative rights. So that's all I want to say. And I appreciate your time and attention to all these matters.
I'm sorry it got heated, Mr. Savage, but
No, that
these
was,
things happen.
it does. It's, it's a very this is a very frustrating situation. And, in our view, we saw this, that Permian was attempting to adjudicate title, and we felt strongly that that was not appropriate. So I appreciate your diligence and attention to detail.
Of course.
On that
Before
note,
rule
I
on the
do want to be
motions-
clear that Permian has not been trying to adjudicate title.
Stand, Ms. Vance. Thank you.
That's
Miss
a
Luck.
misunderstanding from the other parties.
Yes. Miss Luck, anything further?
Nothing further. Thank you, Mr. Hearing Examiner.
All right, so for the Carolyn Beal motion to strike Exhibit C12 and VF's concurring motion to strike C12, those are granted. I've already stated that. Permian's motion to strike intervention in 25146 is denied for obvious reasons. And then we had the motions to limit the title dispute as irrelevant, blah, 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 for today's hearing. Well, those are denied as well. The way I look at those is that the hearing examiner has the power to admit relevant and reliable evidence that is not redundant. If the parties ever think that something is unreliable or irrelevant, they can make an objection at the time that the evidence is offered, and we'll have a little ruling about that. Anyway, I don't need to predetermine these things in advance of the hearing. So thank you for everyone's attention. It is now 2:35. We're off the record. Thank you.
Thank you.
Thank you.